So we go from mainframe software to Linux to Android to smartphones and then to artificial intelligence. What stayed the same and what remains different? All right. Number one thing that remains the same is the challenge of interpreting this foreign language to a lay audience, to lay decision makers. It is the principal task, I think, of a great IP litigator to be able to analogize things.
Welcome back to CZ and Friends, where we talk with legal leaders, technologists, and operators who have been in the room where the big decisions get made. I'm your host, Cecilia Zanidi. Today, my guest is Michael Jacobs. Michael spent decades at the center of the biggest technology disputes of our time. Cases like Oracle versus Google, Apple versus Samsung. These were the cases determining policy and law for the tech that we use every day. For context, Michael was I think he was the managing partner of the firm or of the San Francisco office when I was a baby summer associate back in the mid 2000s. He was a mentor to me, and I feel so lucky to have him on the show today. Michael has what is known in the Valley as some of the best judgment and one of the best litigators around. But part of what makes him so great is this deep obsession and understanding of tech, of dynamics, of things in society. We're going to get into it. It's going to be so much fun. Michael, welcome to the show.
Thanks, Cecilia. It's great to be here with you. It's great to see how things have progressed since those early days. I actually knew you when you were at Yahoo. And so our careers together have spanned the life of the internet.
Literally, yeah. So I started off my career, yeah, incredible. So I started my career as a paralegal at Yahoo, and Michael was our outside counsel on some big cases. So that's literally how long we've been working together.
And
Incredible.
if you think about it technologically, we've spanned from category search to AI-based search. And so we've seen a lot.
Incredible, incredible, and literally Facebook did not exist, I think, or Facebook was pretty new and still doing corporate invites and college students only at the time that Michael and I met. Quite a lot of context, but big cases, I guess, like, what I would ask is, how do you let's see, let's dive in. Let's go straight to the heart of one. You've worked on multiple billion-dollar cases, billion-dollar plus cases, Oracle v. Google, Apple versus Samsung, of course, huge, famous, kinda household name cases. When you've got a litigation where billions are on the line, put us in that moment. You get the call from the client and then kind of walk us through what that's like.
Among the things that it's like is an effort to think down the road as far as you possibly can, even at those initial stages. So when you're drafting the complaint, what are the implications of pleading this cause of action versus that cause of action? These are pretty basic lawyering tools. But when it's a case like the one you're describing and you're on the plaintiff's side, there's a lot of drama associated with those initial decisions and a lot of back and forth with the client about what it all means. I think one of the other things about a big case like that is the difference between your interactions with say, your interface and then what you know is going on behind the scene. In software terminology, we're talking about a lot of information hiding going on. You're dealing maybe with the head of litigation, sometimes with the general counsel, but behind that person are all these discussions with the executive team. What I tried hard to do when I was representing clients is understanding the nature of my immediate contact's duties internally. I was trying to give that person the right words to say to their internal audience. And that's just key because you have to look behind what you're seeing right in front of you and understand the dynamics of a corporation. Even at the board level, there may be discussions that are pretty serious about big cases.
So you referenced the general counsel, who of course is a lot of our listeners. In a case like that, where have you seen general counsel perform the best? And you mentioned that, like, understanding the dynamics, understanding the board, a case like Oracle v. Google, there was, of course, the famous email that was like the smoking gun email that I love. We'll drop it in the show notes, but TLDR was an email that said something along the lines of, we got to get a license. And that was the issue in the case. So, where have you seen GCs really just like be amazing? And in particular, when that many dollars are on the line, how do they do it? And how do you help?
Well, so it's a big allocation of resources. Obviously, financial resources. These cases are really, really expensive to litigate. We submitted a fee bill in one of those cases at the end of it of approximately $50 million. And that was after
That was in one
trying to
month?
Yeah, right.
Wow. All right.
No,
So
no, no, no.
gross for $50 million bill in a month. Let's go.
No, 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 no. $50 million for the case. A
Total.
fee
Okay.
bill,
All right. I feel a little bit better about that. I mean, I remember
a
back in the
fee
day, patent cases was like 500,000 a month, and that was like huge. So
no, that was a realistic amount, but this was no for the life of the case at the end after we won. So, and the leader at the client, whether it's the general counsel or the head of litigation, or in one of the biggest cases I did, just an executive who was tasked with running the case, they get heavily invested and they want to know everything that's going on. They without micromanaging. I mean, that's a trick of this, right? Is being fully informed and aware and involved in key decisions, knowing when to ask for involvement. I would like to be involved in that, knowing, but at the same time, having a relationship of mutual respect. I think the best word is partnership, a genuine partnership between the leader of the team on the client side, let's call it the general counsel for the moment, and the leader of the team on the outside counsel side of things. There's some other little techniques. It's important to know who the staffing is. It's important to know who the day-to-day contact is versus the person running the case at at the highest level. I tried very much as lead counsel to stay involved from the beginning through the end and to be up on everything that was going on. I think that's something that a style point about lead counsel that in-house counsel should be aware of when they're choosing lead counsel. That facilitated that partnership.
any good, obviously you'd have to generalize, but any good stories on that point? So I'm thinking, so I was involved in Apple Samsung, and it was probably not a surprise that, there were, I think, maybe half dozen law firms on each side. And, the number of discovery motions, I think I was excited to that I got to like write one or something. So like hundreds of discovery motions, very, very complex, multi-jurisdiction, multi-statute, multi-defendant, huge. Any stories on that point around kind of keeping things apprised? Obviously, you don't want to surprise people, but has it ever anything to share with the audience about it going right or wrong?
More some things we saw on the other side.
There
Uh,
you go. All
so
right, let's go. Let's go. Let's go, litigators. Let's go.
So there were some serious problems with the other side's client management, maybe internal management, including management of time. We were on a time trial and we came in with a couple of minutes to spare and the other side was scrambling for time. There were some issues with managing discovery updates in the case that led to important evidence exclusions. And attribute that somewhat to a lawyer client relationship in which the lawyers were not encouraged to come in right away, learn all the facts, get all the details, pick up the best and most important documents so that they were able to chart out how the case was going to go and what the big defenses were going to be. So, and I think my interpretation was the lawyers were kind of kept at a distance and that made it hard for them to plan, hard for them to strategize. They were capable lawyers. They There was a little bit of a hamster wheel going on the other side as well. A lot of activity for activity's sake. But when I think about some of the big strategic moments, I attribute it to a lack of a good partnership between law firm and client.
I love that. So, would you see it as kind of a flavor of just management in general, right? So, like, when I think about we had a in my career, I had an executive that I worked with, and I've worked with in the past, and seen this happen where the person wants to kind of uh, build an empire and not be a good partner to peers, and it's just fatal. Like, it's like, it doesn't work. Is it a flavor of that dynamic? Or, like, if I wanna get good at that, so I am, let's just pick a name, with the leader of the case on the other side in your case, you attribute it to this error. Like, what should they be doing? And is it like any other kind of management, or is there something specific in litigation context?
There are specifics, but I think you're onto it. I used to describe the launch of a big case on either the defense or plaintiff's side as opening a new line of business. And you should think about there are certain range of outcomes, there's certain risks, there's certain opportunities. You do a SWOT analysis, you do the classic things that you do when you're thinking about venturing into a new market or launching a new product. And similarly, the amount of communication that should take place, the authority that's given, where do decisions reside? Who is the decider? Classic question in internal politics, right? Who's the decider? And so I think you're right on. And the same kind of errors can occur. Would we open a new line of business and spend millions of dollars in that without doing A, B, and C, where A, B, and C are basic tasks of what we would call litigation management? But I think you're dead on. It's management.
Yeah. No, that's fantastic. I mean, I think it's interesting because that phrasing of "Would you open a new line of business?" I still remember. So my first startup where I was head of legal, Anki, it raised a Series D and then ultimately, stopped operations. We had, and this is public, the series of basically patent cases, and there came a question whether we should sue others on patents that we had. Funny enough, it was part of the reason I got the job was that I had been a patent litigator at MoFo, and so that was actually my GC journey. So side note for listeners, like, random stuff in your background will absolutely help you get the GC role. There's not a linear path. But separate from that, my first day I walk in, they're like, "All right, we're gonna sue Mattel." And I was like, "Okay." So Mattel has at the time 150 lawyers or 150 folks in the legal department. They're very serious about enforcing IP. They've sued artists over Barbie, of course, the Barbie Bratz case, which I also build on. But anyways, lots of cases. And I didn't phrase it that way of do we want to open up a new line of business? But I knew it was a bad idea. Like I was kind of like, like it just does not make sense to be a plaintiff here. We're a startup. We're going to try to win the market. And we were winning in the market at that time. But that raises the question of like, is this just a Fortune 100 company game? And when you get clients deciding whether to be the plaintiff, have you ever discouraged them from filing suit?
Yes, I'm thinking of one case where a major US industrial company came to us. This was after Apple, Samsung, and they wanted a replay. And we looked at the we looked at the record, and we had to tell them about some warts in their case that would affect the unfolding of this new venture, this new line of business. And it's the end, we're kind of pessimistic on this big case. And I felt very proud of us. This was a law firm basically saying to a client, don't spend a lot of money on us because we don't think this is going to that this is going to go as well as you want it to go and create the kind of boom that you want to create. And sure enough, the company decided not to go forward, which I think also was probably the right decision.
Wow. What was that like as a leader in the firm to make that call? And did you have peers who might have suggested otherwise? I mean, obviously, I don't wanna reveal any information, but, like, that's a hard call. So
I think
we talked the other day, a girlfriend of mine is at a big law firm that is still litigating a bunch of tobacco and asbestos cases, and they had a partner who said, "Hey, you know what? I'm not gonna take my partner's share of the tobacco cases," and just made that call, and it was sizable. It was maybe, let's say, I don't know, 10%, 5%, whatever it was of the share, and they calculated, did the math. I viewed that, I was impressed with that this person had, family history of lung cancer and so on and decided to make that call. But similarly here, I mean, I guess it gets to the partnership thing, but did that client come back for other matters? Like, put us in your head at that time.
the client did come back to us for other matters. And I guess I believe very strongly in our ethical duties as lawyers to our clients to put their interests first, to put their interests over our financial interests. That's what it means to have a fiduciary duty. Also, the Morrison and Forster ethos was very much that kind of sense of duty to the client, of placing the client's interests first. And so I had no internal pushback on that. By way of reference to your other comment, long ago, Morrison Forster decided not to take on tobacco industry litigation. And you're right; those are big cases. There's a lot of financial implications to not taking those cases on. I think and I wasn't part of that decision. I was part of other similar decisions later on where we just felt like, if we're going to be doing this, are we going to be enjoying coming to work every day? And the answer was no.
Yeah, I love that. So you've been on these cool cases that mark kind of the history of tech, right? So Apple, Samsung, the rise of mobile, Oracle, Google with, open source and internet. It's of course public that Morrison Forster represents I think you represent the New York Times in the
Actually,
OpenAI and the New York Times lawsuit against
right.
OpenAI, which is of course big case of our era on copyright over training data. What has changed about these big cases and what has stayed the same?
That's a good question. So just to expand the lens a little bit, my first big case, the case that actually made me into an IP litigator was for Fujitsu against IBM, and the issue was mainframe operating system software.
Wow. So
So we're
really
talking
truly a walk down memory lane. I love it.
down memory lane. We're talking mainframe computers. We're talking Japan as the emerging rival to the United States and all the trade tensions that that created. And then what I think is the case I actually did the best lawyering on was a case for Novell involving Linux and Unix. And this was SCO Group versus Novell. It was Boyce Schiller on the other side claiming $1 billion in another $1 billion case, claiming $1 billion in revenues from sales of Linux, which they claimed included Unix code, which they claimed they owned. So there are a bunch of claim in there, but it was a fascinating case. Tried in Salt Lake, won on summary judgment, reversed on appeal. Tried in Salt Lake City, defense verdict, affirmed on appeal. Bankruptcy proceedings in which we went after, we were a plaintiff. All sorts of ancillary. There was even an arbitration in Zurich for a while going on. So multi-front battle, great internal partnership, just the best relationship with the client, and we got a fabulous result. So that was all about Linux. So we go from mainframe software to Linux to Android to smartphones and then to artificial intelligence. What stayed the same and what remains different? All right. Number one thing that remains the same is the challenge of interpreting this foreign language to a lay audience, to lay decision makers. It is the principal task, I think, of a great IP litigator to be able to analogize things in a way that makes sense. I'll never forget Bob Van Nest wheeling a file cabinet into the courtroom on day one of Oracle Google and saying, these APIs are just like a file cabinet. And it actually wasn't that good as a technical analogy, but he kind of owned the physical space at the time, wheeling in a file cabinet. And Bob's a great trial lawyer. Over time, did very well in that case. So that's a challenge, I think, is the first challenge. The second related challenge is applying traditional legal principles to new technologies. That remains the same. In the Fujitsu IBM case, we had just decided as a country that copyright would apply to computer software. And there were very few cases explaining what the scope of protection was. And as each new case came out, the complexion of our case would change because, oh, we got another milestone on this. And now fast forward to for example, the OpenAI litigation on which I served for about a year, translating copyright principles of the most traditional variety to the most advanced technology, an LLM that is both ingesting and then processing. So that is ingesting, processing, and then outputting information. And at each stage, there's a potential claim that needs to be evaluated and traditional copyright principles. I think what's new is the pace of change and the pace of new company formation around that change and the relative innocence, if you will, of those companies to litigation. So, of course, Fujitsu did not have a lot of litigation experience. They were a Japanese company, but they were well developed as a company. I mean, they've been around for decades. And IBM
I
in
mean,
Fujitsu
literally
were
is like the 100-year-old, whatever. Nobody ever
exactly.
gets fired for hiring them, et cetera. Yeah.
And they had their relationship with Cravath. And in fact, what had happened is, as a lawyer's sociology matter, IBM had just, in a sense, prevailed in the US v. IBM antitrust trial, the antitrust case, the biggest case to hit
Yeah, yeah.
American technology up to that time. And so they took those Cravath lawyers who had represented them against the government for 10 years and turned them into IP litigators. And they came after Hitachi and they came after Fujitsu. And so well-established companies, lots of resources, and at least in the case of IBM and Fujitsu v. IBM, lots of litigation experience. Now you turn to what's going on in AI, for example. These are brand new companies doing brand new things, like trying to train an LLM with brand new relationships with lawyers. And so I think that creates it's a different dynamic. Companies are doing things that maybe more established companies would have different procedures governing and different relationships with counsel, well-established relationships with counsel and that know the business. And so I think that's an interesting novel aspect of the current era.
Well, and I mean, you think about, I think OpenAI now they're in the thousands of employees, and just a few years ago it was probably like 100. And similarly with Anthropic, and all these other companies where when you've got, three-quarters of the company is new in the last year, just like who does what, how do you even manage the case like that? I hadn't really thought about that aspect. It was somebody mentioned, okay, pace that we have of AI adoption, we've got in the billions of users now for at least ChatGPT. It would be as if the automobile came out and 18 months later everybody was already on automobiles, when in fact that change took a decade or 2 decades to happen. So I hadn't thought about it on the litigation side. That's interesting.
Well, and if you think about it, so I'll go back to my Fujitsu representation. There was a guy who was responsible for that line of code.
Mm,
And so you knew ultimately, if you asked the right question, you would get to the guy who was responsible for that line of code. And he had been working with the company already for, say, 10 years, and he was going to work with the company for another 25 years. And so, in a sense, it was easy to get to the facts. It was, looking back on it, of course, it was a huge challenge, but it was not a challenge of I don't know how we're going to do this. It was how do we get to the right person in a foreign language in a foreign country. Now think about the companies that are litigating now and just how hard it is to find out what happened, who did what here.
amazing. So you were actually trained in diplomacy before you became a lawyer. You were in the foreign service. Tell us about that, and how did that experience of literally being a diplomat affect your litigation career?
It was a great experience. I was a young college graduate and I went into the Foreign Service having concentrated on Russia and Eastern Europe in college. And so they sent me to Jamaica as my first assignment, where I was a consular officer manning the visa line. And so I was a classic bureaucrat. And and it was just an eye opener in so many different ways. Then I went to Washington, D.C., and I was in the Bureau of Intelligence and Research working on arms control issues, which had some relationship, at least, to my areas of interest in college. And that was the Washington, in a sense, classic bureaucrat. And I mean bureaucrat not in a derogatory sense. I mean, a bureaucrat is a government official responsible for adjudicating or working on projects. Number one takeaway that affected my work as a lawyer is understanding who the client is. I think this is a huge point of confusion that I saw in the Foreign Service. You really are kind of a lawyer for the government, and the government is your client, or the people are your client through the government. But you don't have a, or maybe shouldn't have, a strong independent policy view. Your job is to effectuate the elected officials' decisions about foreign policy. Now, having said that, there are interstitial aspects of the job where you have a ton of autonomy. May not really be a client. And one of my favorite stories about the Foreign Service was when I was in Washington and I met the Polar Affairs Officer. This is a guy who was responsible for the North Pole and the South Pole. And among his perks is he got to go to Antarctica twice a year to visit the multinational installations down there. And I talked to this guy and I realized in a way in this obscure job, it's the best job in the State Department building because he's the guy, he's the person. He's the officer in charge. Nowadays, the Arctic and the Antarctic are a big deal, so I suspect this isn't as true as it was then. But I think he just probably had a great time. He got to decide what our policy was for the North
That's
Pole.
great, that's great. No, I know, it's always like, here in SAS, we're like, "We have customers on 6 continents," or whatever, like, "Can we actually get Antarctica?" Like, "Is there somebody buying software in
Uh,
Antarctica? Let me know, because we'll sell to them." Alright, amazing. So, that's obviously one of the things that you moved into then when you went into litigation was these, like, super high stakes matters, and you had the, like, who is the client and kinda how do you tease out that judgment. In the prep for this, I was thinking you've probably seen, and one of the things we've talked about here is on this pod is like just this decision making at high pressure. and that as the GC, you're gonna have to deliver bad news. You're gonna have to make those calls. And we had one of my favorite episodes with my friend Rebecca Fike from the Securities and Exchange Commission. Now she does basically white collar litigation defense and investigates fraud. And so when she's coming in, she's like, she made a point to me that she said, when I call with what's happening when the SEC investigates you, she's like, I actually don't really make too much of a friends with the GC or who I'm talking to. She's like, I'm pretty straight that like, this is going to not be fun. This is how it's going to be. This is pretty serious, but I'm going to help you and it'll be okay. But she does not bias too much on the it'll be okay side of things. Would you agree with her, and what would you say about those moments where you're delivering bad news or your client is somehow under what is objectively a ton of stress?
Yeah. One of the, I think, specific challenges of being a litigator, a trial lawyer, is distinguishing your voices. Voice number one is your advocacy voice. It's a courtroom voice, of course, but it's also a voice of the client in which you reflect the client's views and understanding of a situation so that they know that you are hearing them and that you are their advocate. You are their spear carrier. You are their warrior. You are not there to second guess in that voice. You are not there to second guess them. You're not there to tell them all the warts in the case. You're not there to tell them all the downfalls and risks. You are there to demonstrate that you're going to be a strong advocate for their position. Voice number two is the advisory voice. That is the voice where you have to give honest, straightforward appraisal of the situation as you see it. And you can't sugarcoat it because, again, this topic we had at the beginning of our conversation, there's an audience beyond your audience. And you have to be giving your audience your immediate audience, the words to use for his or her audience. For if you're talking to the GC, you want her to know exactly what she should be communicating internally. You might even want to say this in hack verba. Here's what I think you should be conveying to your team. This is going to be a long and difficult road. I don't want you, my GC client, to get caught up in sugarcoating it for your audience because they're going to remember that. So let's give it to them straight. And then being clear both with yourself and with your client about which voice you're using in which moment, I think it's a really challenging thing to do. What I see both errors on both ends. I see lawyers who get into this mode with their client where the client's all revved up about things and the lawyers are like poo-pooing all over it. And not first demonstrating voice one, I get it. And
Yeah.
let's go there. Let's take that. Let's see where that argument goes. Let's run with it. And then, okay, now let's step back and let's get rational about this.
We did have one of our Diane, Honda from the former CEO of Redis, who's been a GC of a bunch of software companies. She said she physically has the other voice be like the other chair in the room, like the Amazon thing of like, who is the dissenter? And literally just like makes a note to go ahead and do that. And I just anecdote on my side, I was actually opposite Morrison Forster once and do not recommend 0 out of 5 stars. But anyways, I was opposite Mofo on a case and I would say this is probably one of my biggest regrets as a GC is that we talked about the cost of the litigation, but I believed so vehemently that we were the defendant in that case, that the case was BS. Like it really literally was. And we can transition to your being an arbitrator because literally it was to the point where the arbitrator told me I said, "This is not just, like, what the heck is this?" And she said something to the effect of, like, "Sometimes you gotta pay money to get crazy people out of your life." And I was like, "What the heck?" Like, anyways, it was a I believed it to the core that this was a terrible case, but my mistake, and I think it was probably what you described, was that when I told it to the client, to the CEO and the board at that time, I said, "Here's what it's gonna cost." But no chance it's gonna cost that because we're gonna settle it early because it's BS. And so I had the number, the seven-figure, number in there for what it was gonna cost, and 7 figures at the time for the startup I was at was a lot, and that's exactly what it ended up costing. And in
Didn't
retrospect,
settle
I
out.
remember very clearly the meeting where I was like, "Oh, here," and I remember one of the board members, to their credit, was like, "That's, that seven-figure number, that's a big number." And I said, "Oh, that's fine." Like, I kinda I mean, sugarcoat is probably too strong, but I definitely did not underscore that point, even though it was absorbed. So I feel okay that I gave, adequate advice, but in retrospect, I think if I was it was my first GC role at the time, if I was more, experienced and had that, if we'd had this pod before, I probably woulda done this. So what have you seen? So what do you how do you do that? Like, do you do it in writing? Do you, like, any great examples of that? And then, I guess it's worse, right? 7 figures of bills later and you're still losing and it sucks. It would have been better, to be honest, in the first instance, huh?
Exactly. I really some of the most awkward moments are where we just underestimate it. And and then the client saying, "Yeah, but you told me it was gonna be X, and now it's way over X." And I said, "I did the best I could at the time," but it is a very awkward situation. And in a competitive world, you're tempted to not overprice, if you will, not give an estimate that's high because the client is taking these estimates internally.
And turning around and putting them in a board deck. Yeah, that's
Exactly,
exactly it.
right?
Yeah.
And so if you will, the high bidder, even though it's not really a bid, I mean, there's some fixed price thing going on, but if it's not really a bid, but if you're a high estimator, then why are you choosing them? They gave you a higher estimate. Well, they're better. Really? How do you know they're better? What does
Yeah,
it mean to be
exactly. No,
better? What
yeah.
does better mean? So
I mean, so that's a perfect segue actually to the future of legal. So you talked about alternative fee arrangements. This is the first time with AI where legitimately, we get stories every day from GCAI users saying, outside counsel law firm X quoted me 1K for this regulatory research. We turned around and did it in GCAI in 2 hours and it was adequate and perfect and great. Tell me about law firm revenue in the age of AI and what you think is going to happen.
well, let me describe what I think is the law firm challenge, and I'm indebted to one of my colleagues for having framed it, my former colleagues at MoFo for having framed it this way. The job of the law firm now is to deliver a product that's better than the AI product, and to be demonstrable about that, and if I were in a law firm and my associates were as they should, starting out with GCAI or one of the other tools, I would say I'd like to see what you got, and then I'd like to see how you improved it. And if you can't do that,
And what are
then
you
I don't
selling?
know.
Yeah, exactly. No, it's true, and I mean, I think this is the thing is that, you know, I do the same thing with marketing. So when I get a blog post that I had written, and by the way, I work in AI, so it's very, I can still tell, very obvious AI tells. But if it's not bespoke enough, if it's not strategic enough, if it doesn't connect with the customer enough, of course, y'all know I love to tell stories. We're sending out a marketing email this morning about our playbooks feature. I'm talking about the hairiest contract I ever read. So like that ability to infuse that human element, that's what I see at least on, in other functions. So within legal, what would that look like? So tell me like a regulatory project in this scenario, they were looking at state by state laws around some kind of reimbursement of partners and it was in the transportation sector, so regulated both by the feds and the state. Anyways, what would it look like in that scenario for the associate or Morrison and Forster or any firm to add value over AI?
Well, there's first just the checking, right? There's the quality checking to make sure that there are no mistakes, and we know that just as associates can make mistakes, AI associates can make mistakes,
Yeah.
and I think that's the right way to think about the AI tool. The AI tool is a good second or third year associate right now, and and so whatever you would do with a second or third year associate if you're the partner is what you should do with the AI tool. Except you have to be doubly worried about just gross. We still have to be worried about hallucinations. They're being mitigated, but we still have to worry about that. Then I think you put your finger on it. I think strategy. I think that the human ultimately a human is dealing with a human. This is the part of the AI world that I don't think we've really grasped. But when you put together your panels, for example, for GCAI, you are having humans get on stage to talk to humans. And I could use AI to help me prepare for that panel, but ultimately, I was taking that AI information and I was processing it for my voice, my human voice to talk to humans. And it's similar in litigation. Ultimately, it's humans talking to humans and thinking strategically then about what you want your voice, your human voice to be to that human audience is, I think, the deep layer of what humans add to artificial intelligence, and it's an ineluctable layer as long as we're humans talking to humans. If it's AI talking to AI, well, then no. But in court right now, it's still, I'm going to say it again, humans talking to humans. In my mediator or arbitration role, I'm a human receiving briefs, and I have to process those briefs. I have to come up with what I think my view is. And the more those briefs are tailored to reflect a sense of strategy about what the lawyer is trying to convey to me, the better quality it'll be.
I mean, that human point is like we recently had our GCI summit, and one of our investors, Ashton Kutcher, made the same point around commercial contracts, right? So everyone is very excited about AI for commercial contracts. And on the GCAI side, we have a plugin in Word or a Word add-in where literally you just tell what to redline at redlines. We launched a playbooks feature where all of your positions that, formerly painstakingly negotiated by humans, indemnity, limitation of liability, commercial terms, what have you. The AI can basically apply the first draft. And it's not hard to imagine a world where you've got the AIs exchanging the drafts. But Ashton made the point, which I think is a good one, which is like you're going to reach ultimately a contract is like the meeting of the minds, literally. And you're going to reach this like basically impasse where what you're trying to communicate is what are humans going to do together. And so like at that point, like it's the same thing where it's like the level, like in the case of the regulatory example, the computer does all the polling, but then like, okay, implementing it, advising on it, that might be a simple example where, okay, this particular client, the law is clear, the law is no longer paywalled, they know what they need to do in these 50 states. But like, hey, can you take the risk in Tennessee because the AG is asleep at the wheel? Maybe. I'm not saying, of course, subject to ethical guidelines and so on, but where it's gray, where it's black and white, I think it's going to be less hard. But where it's gray, that's where I think you can add the value. Or I always talk about my friend again, the one at the Securities and Exchange Commission. She's got a high billing rate because she was at the SEC for 10 years. And she knows exactly all the human elements
Yep.
around securities law. So very
Yep.
similarly for other kinds of law. All right. So now you are a judge. So you've got the real human element. You said something at dinner the other night. We had a dinner for the GCAI event. And you said something like, I think I told you about the BS case and my experience with the arbitrator. I said, well, what do you think of the case or something? You said something like, okay, to the plaintiffs, I always say, this is shitty, this is not a good case, and you should settle. And to the defendants, I say, this is expensive, and you should settle, or just something like that. But so what was your mantra? And then what is it like to be an arbitrator now or mediator?
Well, so the I'm really enjoying it. I find the role really satisfying, in part because I get to use all my experience and all my skills to try and either help people resolve a case or resolve a case in the case of mediation versus arbitration. And I had some clear ideas about neutrals when I was in practice, what I liked and what I didn't like. And so I'm trying to now be on the other side of it. I'm trying to be the neutral I wanted when I was in practice. And the I one of my internal rules is that yes, I will say to the defendant, here are the risks, and I will say to the plaintiff, here are the weaknesses, but I will not say give different evaluations to each side. I say to them, and sometimes I'll do it jointly, say to them, I want you to know I'm saying this to the other side about the case. And this is what I'm saying to you about the case. And they're in alignment. I don't believe in telling you you've got a weak case as a plaintiff and then going to the defendant and saying they've got a strong case. I just don't think it's not the way I want to practice in the case of mediation.
Yeah, I'm trying to think, one of my mediation experiences, I don't think it was a good mediator because it was about, it was a mofo case, and it was about additives. There's a lot of technology, it turns out, around that we can get clean salads now, right? Like, basically, like, you go and you buy, like, a bag of spinach or whatever, and you don't have to rinse it. Like, turns out there's a lot of technology there. The mediator kicks off the case. This was 2 people, some kind of basically preservatives, a fancy form of citric acid that would make your box salad last forever. He basically, or maybe his gas, I don't remember exactly the tech. But he kicks it off being like, "I don't eat, your crappy box salad." And, like, literally everyone in the room is like, "Well, now the mediator has insulted all of us." I think that comment set us back, like, 3 hours. It was crazy. But any fun comments on mediation either that you've been in, any, like, tactical stuff? I was told to bring granola bars, which I did, but any, like, get real, like, our listeners really like practical. So what practical advice do you have on mediation besides don't hire a mediator that insults everybody in the case when you
Faults
kick off?
everybody in the case. That sounds like someone very inexperienced.
Yeah, no, I don't know. Like I said, 0 out of 5 stars, do not recommend.
Well, I think cases nowadays are because clients are sophisticated in the realm in which I practice and the lawyers are sophisticated. And it's a question of what value can we add, right? In this human to human process. They the lawyers have worked on settlement, maybe they've had settlement discussions. And so where are we doing something that's different? That is why I have chosen generally to be an evaluative mediator. Some mediators refuse to evaluate. It's just this is what the other side is saying. But I think, why are you hiring me? Why are you hiring me just to be a go-between? I think you're hiring a human because you want a human reaction. You want a little mock jury in front of you or mock judge. And so that's one aspect that one way I've landed in sort of carrying out the role. On the arbitration side, I am I'm a careful reader of contracts. I think the space between contracts and practice in terms of adherence and conformity in many companies is really wide. And partly it's because the function of drafting them is outsourced to contract drafters. But it's actually managers on line businesses who need to report in 60 days on what's happened and what are you talking about? What 60-day thing? I never signed up for that, right? If they're ever told about it at all. Uh, so as an arbitrator, though, I think my job is really to do a careful job of contract reading. But that is represents the meeting of the minds, to use your phrase, right? Whether
Exactly.
it was lawyer to lawyer or business person to business person or AI to AI.
That's what it says. No, I know, and it's crazy because I litigated a case also where there was a typo on a document because it was in January and they had the year of the prior year on it.
No,
Every deposition, everybody agreed it was a typo, but it was like every deposition we had to say it because it was like, "Can you please confirm?" It says January 20th, 2025, but they meant January 20th, 2026. Okay, yes, all right, move. But yeah, no, I think that's an interesting point. A lot of our listeners are commercial counsel. So your best advice, having litigated at this point probably dozens, if not hundreds of contract disputes. Best advice for people drafting contracts.
remember that some human being who is not a likely not a transactional lawyer. I at least spent a couple of years as a transactional lawyer, so I did some contract drafting. But if it's a typical judge or if it's a jury or even a typical arbitrator, they are not contract drafters. And so your audience in the event of a dispute is someone who is, are you really going to send them from the definition section to another definition, and then have an embedded definition in the substantive clause itself? What are you doing here? How,
Yeah.
how long does the decision have to be to explain how you get to the relevant question under the contract?
Yeah, yeah. No, I mean, this is something that I actually think AI has a role to play here because I tell people if your contract is easily readable by AI, it's probably also easily readable by a human, in which case, like, we had, for example, again, we launched this playbooks product and, the core product is like some people have had playbooks for a long time, how they're going to negotiate contracts, they have fallbacks, et cetera. And we had a customer come to us that had a fallbacks guide with fallbacks nested 8 layers deep. So if they say this, you do this, you do this. I'm like, are you really having 9 turns? Like, and of those 9 turns, is the fourth one like where maybe you should start? And so, like, just thinking about that, like, and it turns out, we've got other customers that have playbooks that are just like a checklist. Does the contract do this? Does it do that? Does it do this? And those react beautifully to AI. And to your point about API, it's like, what is the interface between these two companies? Is it simple for AI to understand? Is it simple for everyone to understand? and yet cover the detail that you need. Like that is probably the thing that I see people debate the most is like everybody wants the one-page contract, but then it's like, oh, well, what happens if this? What happens if that? And those things come up enough that, okay, then you've got the human judgment of like, hey, our main services agreement is, 8 pages and it's relatively detailed, but people like the assurance around, that we don't use your data to train a model or things like that. And so it's been really interesting. That's great advice. I love it. All right. So let's go to lightning round. A book, idea, or mentor who shaped how you think.
Book. So if the camera goes wider, you'll see that we had a little poster contest at Morrison Forster for Reading Week or something like that. And the book I'm holding up is Zen and the Art of Motorcycle Maintenance, which was a very popular book many years ago. And what I took from it was the idea of quality. That quality is kind of a lodestar in the book after this long motorcycle journey that the protagonist takes with his neurodiverse son, and he's talking about the meaning of life, and ultimately they land on quality. And I think quality is a great concept to keep as a north star. It covers a lot of ideas, it has a lot of nested layers in it, but I've always found an answer if I ask myself, what is a quality result here? What does a quality person do in this situation? What does quality leadership look like? So that was a book and an outcome.
I love
I
it.
had great mentors at Morrison Forster, and one of them answers a lot of the questions helped me answer a lot of the questions we were talking about earlier. It's Harold McElhaney. Harold had an instinct for strategy. And I think part of the challenge of lawyers is they're giving bad news and they don't know, okay, now what? And what the client wants to know is, okay, do you have a strategy? And if you can deliver really bad news, but if you say, here's our strategy, the client retains their confidence in you because you've thought through to the next step. It's like a doctor giving you bad news and saying, but here's your treatment plan. But they just give you bad news. It's like, what are you doing? What next?
Exactly. No, no, no. What about like, not sugarcoating, right? I always used to be frustrated when I was junior lawyer and I'd go to the doctor or something and they'd be like, oh, you have this. I'm like, well, what are the percentages that I would do that? And they're like, oh, we don't know. It's like,
We
no, you
don't know.
gotta tell me.
Right.
Awesome. All right. Well, one more piece of advice, two-liner advice you would give your younger self.
Two-liner I would give my younger self is no shortcuts. You really do have to dig in and learn the basics. When I joined the litigation department after serving in the business department, I was told I needed to read the California Code of Civil Procedure. That was really good advice,
And
but
you did. Okay.
it
Okay.
has a cognates, right, of when you get into something, read the rules, read all of the rules, read the rules about the rules so that you're not caught unawares.
Love it. I love
Yeah,
it.
that
So
was
good. Litigator's advice, read the rules. That's good. It's a good one. So then you can litigate and fight about them and break them. All right. Good stuff.
exactly.
Michael, thank you for joining me and sharing
Perfect,
such a
Joanne.
grounded view of of litigation, of life, of advice. This has been really lovely. Thank you for joining me.
You're very welcome. I enjoyed it very much.
That was my conversation with Michael Jacobs, who has lived huge cases, lived high pressure moments, and given us great advice to think about in our careers as lawyers and business leaders. Follow CZ and Friends wherever you get your podcasts to learn how legal teams are using AI to work smarter, lead with impact, and read the rules, negotiate contracts, and meeting of the minds. Visit gc.ai. Thanks for listening. We'll catch you next time.